Good day, ladies and gentlemen. Welcome back to our course, Partnership and Corporation. This is installment number 9, and we have gone through the different titles of the partnership. And this time we are now in Title 5. So again, this is your host, your moderator, and your coach, instructor, Attorney Lyndon A. Maceren. Welcome back. So we start our discussion with Section 5, the adoption of the bylaws. So according to the new law, adoption of bylaws can be obtained by way of affirmative vote of the stockholders, representing a majority of the outstanding capital stock. That is for stock corporations. In case of non-stock, majority of its members. The bylaws shall be signed by the stockholders and members voting them, and it shall be kept in the principal office of the corporation, subject to the inspection of the stockholders or members during office hours. So how do these bylaws should be submitted? So a certified copy of the bylaws can be made by way of certification from majority of the directors or trustees in case of non-stock, and countersigned by the secretary of the corporation. So it shall be filed with the commission, and it is attached to the original articles of incorporation. Bylaws can also be adopted prior to the incorporation, so meaning if not yet incorporated, it can be submitted or already adopted by the stockholders. Instead of stockholders, it shall be approved by the incorporators. So there are, because it is not yet organized, so the organizers are the incorporators. So no stockholders yet. And then submitted to the commission together with the articles of incorporation. So the first one, this certification is made after the incorporation of the corporation, meaning it has already been issued a certificate by the commission. But it can be made, submission of bylaws can be made even prior to the incorporation. Okay. So when is the bylaws effective? So bylaws is only effective upon the certification of the commission or the SEC, Securities Exchange Commission. Amendments can be submitted to the commission, but in case of banking institution, building and loan association, trust company, insurance company, public utility, educational institution, and other corporations which are governed under special laws should have a certificate of approval or endorsement by the government agency, which is the governing body of the corporation. Like for instance, the for bank and banking institutions, the governing body is the Bangko Sentral ng Pilipinas. So it should accompany, amendment should accompany an endorsement or recommendation from the Bangko Sentral. For building and loan association, still the same, Bangko Sentral, because the loan association. Also for trust, insurance also. Insurance could be under the, no, it's still with the BSP. And the public utilities, like transportation, with the if it's a land, then LFTRB, the Land Franchising and Transportation Regulatory Board, or if in case it is a shipping company, so that would be the marina, no? The maritime industry of the Philippines. Now, in case of mm, educational institution, so it would be the DepEd, if it's elementary or high school, then CHED, case of higher educations. So these companies, before its amendment of the bylaws, must have recommendation from these government agencies. So what are the contents of the bylaws? It's found in section 46. So these are all should be embodied or provided for in the bylaws. First, the time, place, and manner of calling and conducting regular special meetings of directors or trustees. Second, the time and manner of calling, conducting regular or special meetings, and mode of notifying the stockholders of members thereof. So now members can be, or stockholders can be notified by way of electronic mail. This is a new norm in uh, giving advice or notice. Third, the required quorum in meetings of stockholders and members and the manner of voting therein. So quorum is the body, which is the specific body, number of body, the number of persons in a body that can or that is authorized to conduct any approval or meetings or transactions. No? So without quorum, a meeting cannot be conducted. So the modes, fourth, the modes by which a stockholder, member, director, or trustees may attend meetings and cast their votes. So if it's provided that a stockholder can attend a meeting by way of remote communication or in absentia, then that can be done with the new law. No? Letter E, the form of for proxies of stockholders and members and the manner of voting. So proxies is a written form authorizing someone where the stockholders authorize someone to represent him during meetings and during election. So letter F, the directors or trustees qualifications, their respective duties and responsibilities, the guidelines for setting the compensation of the directors, trustees, and officers, and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the commission. So then letter G, the time for holding the annual election of directors or trustees and the mode or manner of giving notice thereof. So election. Then the manner of election or appointment and term of officers other than directors or trustees. So the officers here is the set of persons who will run the corporation, you know? Like the president, the vice president, the treasurer. Yeah. Then we have the penalties, letter I, for violation of the bylaws, and in case of stock corporations, the manner of issuing stock certificates and such other matters. So in section 47, amendment to the bylaws can be undertaken by way of calling a meeting. No? So it could be done during regular or special meeting, and it should state the purpose. And the purpose should be amendment to the bylaws. So it should be stated as one of the purposes or its main purpose. So the vote required in case of stock corporation is 2/3 of the outstanding capital stock. First, majority of the board of directors should first approve for the amendment of the bylaws. Once the board approves it, it should be accepted or voted affirmatively by 2/3 of the outstanding capital stock of the stockholders. For non-stock, so the first step should be approval by the majority of the trustees, board of trustees, before it goes down to the members of the non-stock corporation. So also the vote required is 2/3 of all its members. However, the stockholders can give to its board of directors the power to amend or revoke its bylaws. No? So they can give such power to the board of directors. Likewise, the members in a non-stock corporation can also give its board of trustees the power to amend or revoke the bylaws. So if there is such thing as given by the members or the stockholders, then there is no need for the 2/3 vote requirement. Okay, if there is such prior power given, prior approval giving the board the power to amend or revoke or repeal the bylaws. So this new bylaws, once it is amended or adopted, then when shall it be effected? It can only be effected upon the issuance of the certificate from the commission or the Securities and Exchange Commission. No? So its effectivity shall only be upon the issuance of the certificate from the SEC. So that ends Title 5, and we now proceed with Title 6, meetings of the corporation. So the meetings can be special or regular. So regular and special meetings of stockholders and members. The regular meeting of stockholders or members shall be held annually on a date fixed in the bylaws. Or if not fixed in the bylaws, it should be on any date after April 15. So if it is not fixed in the bylaws. So any date after April 15. Why? Because April 15 is the filing of the income tax return. So at that time, the financial statements are already out, then the stockholders are already provided, and they can tackle any like division of profits, for instance, or any amendment of the processes if they obtain losses during the operations. So it should be made after April 15 if it's not stated in the bylaws. So the written notice of regular meetings may be sent to all stockholders or members of record through electronic mail or such other manner as the commission allows under the guidelines. So it could be registered mail, or could be done by email. You know? So during meetings, there should be a minuter because the minutes of the most recent meeting shall be included during the meeting. So it can be undertaken what was discussed in the previous meeting. Yeah? So description of voting and the vote tabulation procedures used in the previous meeting. The description of the opportunity given to stockholders and members to ask questions and record of questions asked and answers given. So this is the history of the previous meeting. So it is required that at each regular meeting, the board of directors or trustees shall present to the stockholders or members what has taken place in the previous meeting. So the minutes, the voting, the opportunity given to stockholders or members where they were asking questions, the record how the questions were asked and answered. Then what are the other matters discussed, or if there are any resolutions reached. Then the record of voting results for every agenda item. The list of directors or trustees, officers, and stockholders or members who attended the meeting, and such other items. Then a member's list of non-stock corporations and for stock corporations material information for current stockholders and their voting rights. So a detailed descriptive balance and comprehensible assessment of the corporation's performance, which shall include information on any material change in the business strategy of the corporation, on its affairs and other affairs. No? Then a financial report for the preceding year. So that's why it should be made after April 15. So we shall include financial statements duly signed and certified in accordance with this code. Yeah? Then the internal controls or the risk management systems which are adopted by the corporation. And then a statement of all external audit and non-audit fees. So this should also be laid out in the meeting. Then an explanation of the dividend policy and the fact of the payment of dividends or the reasons for non-payment thereof. Then director or trustee profiles, which shall include, among others, their qualifications, experience, their length of service in the corporation, trainings, and continuing education attended, and their representation in other corporations. In director or trustee attendance report, so meaning the stockholder shall be given to who is the most, who has the perfect attendance, no? Of all the directors or the trustees. So it should be laid out to the stockholders or members. Their age, appraisals, and performance reports to the board, and criteria for, and procedure for assessment. Then a director or trustee compensation report, director disclosures on self-dealings, the profiles of directors nominated or seeking election or re-election. So the self-dealings or related party transactions has already been discussed before. No? So this should be the topics that will be discussed in the regular meeting. So for special meetings of stockholders and members, it can be held at any time if deemed necessary, or as provided by in the bylaws. However, notice of at least 1 week should be provided to the stockholders or members in case of non-stock. So if there's a different date or number of days of the notice, like 10 days, so it should be that is stated in the bylaws, that should be the notice. No? So a stockholder or member may propose the holding of a special meeting. So if you are a stockholder, you can propose for a special meeting. And items to be included in the agenda. So notice of any meeting may be waived expressly or impliedly by any stockholder or member. So if a member or stockholder wishes not to be given notice, then he must make a general waiver of notice. No? He said, and it should be included in the articles or the bylaws. That general waivers of notice in the articles or bylaws shall not be allowed. So not general waivers, I'm sorry. So the waivers should only be in a special meeting. So for instance, so he can give advance notice that he is waiving or expressly stating that he is waiving to receive notice of any meeting. Okay. Now, whenever, for any cause, there is no person authorized or the person authorized unjustly refuses to call a meeting, the commission, upon petition of a stockholder or a member on a showing of good cause thereof, therefore may issue an order. So, let's say a stockholder uh, proposes to hold a special meeting, and this proposal, to whom should it be sent? No? So it should be addressed to the secretary of the Corp of the board of directors or the president. Because these two persons or these two officers, the secretary and the president, are the ones authorized to call meetings. Now, if these persons will not call a meeting, so if they refuse to call a meeting unjustly, it's here, then the commission or the Securities and Exchange Commission, by way of petition of the stockholder or member showing good cause, therefore, will now issue. So this, it will now be the SEC to issue an order directing that the petitioning stockholder or member will call the meeting of the corporation. And by giving proper notice to its to the stockholders. So the stockholder can go directly to the commission and should petition the commission that he be given the authority to call for a meeting. Of course, upon showing good cause to the before the SEC. So the petitioning stockholder or member shall preside thereat until at least a majority of stockholders members present have chosen to form among themselves a presiding officer. Yeah? So it will be the petitioning member or stockholder to preside during this meeting. So unless the bylaws provide for a longer period, the stock and transfer book of membership book shall be closed at least 20 days for regular meetings and 7 days for special meetings before the scheduled date of the meeting. So the date before a date of regular meeting, the stock and transfer book, this is the book that would register the persons who invested in the corporation. So if you want to invest, you want to buy stocks, say you bought 1,000 shares of stocks of the corporation, then you should be registered in the stock and transfer book, okay? But there's a closure of the stock and transfer book, and that is at least 20 days from the regular meeting of the stockholders, and 7 days in case of special meetings. So the book, the stock and transfer book or membership book shall be closed, meaning there will be no new member or no new stockholder coming in 20 days before the start of the regular or special meeting. Or in case of special meeting, be 7 days. No. So this is to limit the late registration of persons. So in case of postponement of stockholders or regular or members regular meetings, there should be a written notice sent to all the stockholders or members at least 2 weeks prior to the date of the meeting. 2 weeks. But we're talking about the regular meetings. The regular meeting is already stated in the bylaws. So that's that's a regular date. Let's say the bylaws provide that the regular meeting is every 10th day of May, May 10. So it cannot be moved. That should be the date of the regular meeting. Every May 10th of the year, or 10th day of May of the year. So if the meeting should be postponed, then notice to all stockholders or members must be given, and at least 2 weeks prior to the date of the meeting. That's here. Or unless there is a different period required under the bylaws. So voting of stockholders and members during regular or special meetings can be done through remote communication, right here, or in absentia. The Commission shall issue the rules and regulations governing participation and voting through remote communication or absentia. Okay. So place and time of meetings of stockholders and members. So for stockholders or members, the regular or special meeting should be held in the office or the principal office of the corporation as set forth in the articles. Or if it's not practicable, should be in the city or municipality where the office of the corporation is located. Okay. Notice of meeting shall be sent through the means of communication. Okay, this is already discussed. So agenda, the notice must accompany the agenda for the meeting. Then proxy should be submitted to the corporate secretary within a reasonable time prior to the meeting. So again, proxy is the written authority that would be given out by a stockholder or member that he cannot attend the meeting. So he is now appointing another person to attend in his behalf. No? Okay. Okay, quorum. What is a quorum? The quorum shall consist of stockholders representing a majority of the outstanding capital stock, or in case of non-stock, majority of its members. So during regular or special meetings, quorum should be the presence of majority of its stockholders. Now, for directors or trustees, uh, the quorum will also be majority, no? But if the bylaws provides for greater number or greater majority, yes, meaning if there are 9 members of the board, then majority is 5. So it requires that in the bylaws it's provided for that at least the quorum should be 7. No? So in that case, uh, majority of its directors will still constitute a quorum, even if it's stated in the bylaws. No? And every decision reached by at least the majority of directors or trustees constituting a quorum is already a valid corporate act. No? So regular meetings of the board of directors or trustees shall be held monthly. And special meetings of the board of directors can be made at any time, depending upon the call of the president, no? Or as provided in the bylaws. So meetings of directors or trustees can be held where? So according to the law, anywhere or outside the Philippines, unless the bylaws provide otherwise. So they can meet, let's say the principal office is here in Cebu City, they can meet in Davao, no? Or they can meet in Manila because it's stated here anywhere, no? So for notice, it should be made at least 2 days prior to the scheduled meeting. Directors or trustees who cannot physically attend or vote at board meetings can participate through remote communication, such as video conferencing, teleconferencing, and any other modes of communication. Or, alternative modes of communication. However, directors or trustees cannot make a written proxy. So there is no proxies allowed during board meetings. A director or trustee who has a potential interest in any related party transaction must recuse from voting or must be on the approval of any related party transaction. So if you are a member of the board and you have another corporation and you are signing or executing a contract with a corporation, then you must inhibit yourself from voting during the approval of your contract. So who will preside during the meetings? It should be the chairman of the board, or in the absence, the president shall preside. So this can in all meetings, no? Either board or stockholders or board of members. So in case the stockholder has mortgaged his shares of stocks, then the one who has the mortgagee can exercise the right to vote by way of securing approval from the stockholder or grantor, no? So it should be made in writing. Huh? So if a stockholder will mortgages his shares of stocks to another person, So that person cannot automatically vote in his behalf. No? How is it done? If he wants to vote, then the stockholder will grant in writing the mortgagee the right to vote. Okay. In case a stockholder dies, then his executor or the administrator or receiver, if he has debts, kasi utang, and other legal representatives duly appointed by the court may attend and vote on behalf of the stockholders or members without any need of written proxy because he's already dead anyways. So, pwede sila ka-attend, no? Provided it should be with the appointment by the court. So in case of joint ownership, if a stock is jointly owned by two or more persons, so who has the right to vote? So they can make, who has the right to vote? Of course, they can authorize one of them to vote. And if there is no written authority or proxy, then the right to vote can be exercised by any one of them, no? Any one of them. For treasury shares, so again, treasury shares are those shares which have already been issued and acquired by the corporation. For treasury shares, these shares have no voting right. So manner of voting: proxy, stockholders and members may vote in person or proxy in all meetings. So when authorized in the bylaws, majority of the board of directors, stockholders or members may also vote through remote communication or in absentia. So pwede siya vote. If he cannot attend personally, he can attend by way of teleconferencing. So it stated that a stockholder or member who participates through remote communication or in absentia shall be deemed present for purposes of quorum, determining the quorum. Okay, voting trust. This agreement by one or more than one stockholders in a stock corporation, creating a voting trust and giving this trust to conferring it to another person who is called the trustee, no? Or trustees. So these trustees can vote for them, no? So in case the stockholder is outside the country, like he is is a resident of the US of A, then they can make an agreement which is called the voting trust agreement, appointing a trustee. So the trustee can therefore vote in their behalf. So voting trust can only be exercised or agreed for a period not exceeding 5 years. So in case but it can exceed for 5 years if the stocks has been made as a collateral of a loan agreement. No? Say for example, you have a stocks, shares of stocks in a corporation, and you need money, so you applied for a loan. So in order that the bank will approve your loan, it required you to secure the loan, and your security now is the shares of stocks. And the payment for the loan is 15 years. Okay, so in this case, the lending company has can exercise uh, voting privileges by way of voting trust that you executed more than 5 years, because the loan is good for 15 years. So this is the exception. No? If there is a loan agreement, then the voting trust can exceed 5 years. But upon full payment of the loan, it shall automatically expire. This is loan, not loan. So a voting trust is in writing and must be notarized, and shall specify in it the terms and conditions. Okay. Voting trust. Okay. Right. Let's go to Title 7, which is stocks and stockholders. A stock is issued by way of a subscription contract. Yeah. You'll buy stocks. Before buying stocks, the issuing corporation will execute a subscription contract between you and the corporation. Okay. And then, but in case the corporation is not yet formed, the subscription that you're going to execute is a pre-incorporation subscription agreement. And this kind of agreement is irrevocable for a period of at least 6 months from the date of subscription. But this is only for an agreement between the pre-registered corporation and the stockholder. No? So how do you acquire stocks? You can acquire stocks by paying cash or by exchanging your property, either tangible or intangible, which is actually received by the corporation and necessary or convenient for its use and lawful purpose. And it should be valued at fair valuation equal to the par or issue value of the stock. Because if the par value is way too high or higher than the fair value of the property that you exchanged, then that is called watered stock. Or you can acquire stocks by performing services that you will render to the corporation. Or if the corporation owes you money, like debts or like bonds, then the bonds can be converted into shares of stocks. Or you can exchange your shares of stocks in another corporation with the shares of stocks of the corporation. Another way of consideration. You know? So once you purchase the shares of stock, you're given a certificate of stock, and the transactions shall be recorded in the books, the transfer book records. No? The transfer is recorded in the books of the corporation, showing the names of the parties to the transaction and the date of the transfer, the number of certificates, and the number of shares transferred. So there is a book of stock transfer, or the stock and transfer book. So stock certificates are only issued upon full payment of the amount. If there is unpaid amount, then you can be subjected to, or the subscriber can be subjected to interest and other penalties and expenses. No? So watered stocks, okay. Again, these are issued, these are stocks which are issued for consideration, which is very low, and the the value of the stocks is very high. No? So directors who approve the sale of the transaction, which is deemed as a water stocks, shall be liable, no? Liable to the corporation or its creditors. Okay. So you should not, if you're one of the directors, should not approve issuance of water stock. Again, water stock, like for example, the value of the services made by a person to the corporation is 50,000, and he's issued shares of stocks, which is 100,000 worth. So that is, so the stocks issued to him are falls under watered stocks. No? So taas kayong value sa stocks, but iyang serbisyo is very small, or there's a difference. No? So the directors who consented to the issuance of the stocks for which is less than the consideration of the par or issued value will be liable to the corporation or its creditors. Even though if the director only has the knowledge and he did not divulge it to other does not file written objection with the corporate secretary, siya knowledge does not file, then he can be liable. No? And what is the liability? Solidarily, no? Solidarily with the stockholder who was issued a watered stock. So that is the liability of directors. Okay. Okay, we go now to the books and records of corporation. These are the books to be kept. The articles, letter A, the articles of corporation, the bylaws of the corporation and all the amendments, current ownership structure, the voting rights of the corporation, including the list of members, group structures, intra-group relations, ownership data, and beneficial ownership. The names, addresses of all the members of the board of directors or trustees and the executive officers, meaning the president, the vice president, etc., etc. Then record of all business transactions, the record of the resolutions of the board, of the stockholders, the copies of the latest repertorial requirements submitted to the SEC, like JIS or the General Information Sheet, the minutes of all the meetings. This must be kept with the record. No? And who keeps the record? It's the secretary. So, however, this all of the information which are found in the books or records is subject to the confidentiality rules prevailing, which are now prevalent in our laws. No? These are the Intellectual Property Code of the Philippines, the Data Privacy Act of 2012, the Securities Regulation Code, and the Rules of Court. So you cannot, if you are going to get records, then you have to keep it to yourself. You cannot divulge it publicly unless there is approval from the corporation or the person concerned, because you'll be bound liable under these different laws. So a requesting party who is not a stockholder or member of record, or is a competitor, director, officer, controlling stockholder, or otherwise represents the interest of a competitor, shall have no right to inspect or demand production of corporate records. Okay. So let's go to financial statements. A corporation shall furnish a stockholder or member within 10 days from receipt of the written request for its most recent financial statement, the form and substance of the financial reporting required by the commission. So a stockholder or member can request by way of a request for a copy of the financial reports, and by way of in writing, no? And within 10 days from receipt, he'll be given. So corporations are required to have a audit report when its assets or liabilities exceed 600,000. So if it does not reach 600,000 pesos, then there's no need for audit report. Now, for audit reports, it requires the certification and under oath, or the statement of oath by both the treasurer and the president. No? So na sila dito ay ipirmahan nga verified statement. It's called verified statement. Okay, so that ends part 9, which is titled 5, 6, 7, and 8. If you have any questions, clarifications, you can email me at my Gmail account or Facebook. Have fun and keep learning. Thank you.